Welcome. Good afternoon, everyone. My name is Nancy Oakley. I'm your Education Events Manager here at Citrus Valley Association of Realtors. Today we are here with Paul Velasco of Velasco Law Group. We're talking about estate planning and trust funds and real estate. The session is being recorded, so if you have any questions or you'd like to go review it, please do so. Visit our cvar.live site. It's cvar.live. That's where the recording will be posted probably by the end of the week. So if you want to review it after the session today, we encourage you to go back and rewatch in case you missed anything. So like I said, today we have Paul Velasco. He's an attorney with Velasco Law Group, and he's going to be talking about everything exciting with trust funds. So trust funds, estate planning, how it affects you, all that great stuff that we as real estate agents, we deal with every day. So great. Welcome back. Happy New Year. And I'm going to turn it over to you, sir. Thanks.
All right, thank you. Appreciate that, Nancy. All right, well, welcome everybody. I don't know how many of you have been on the presentation that I've given before. I give presentations fairly often, and I believe I gave one to this particular group back in August. So happy New Year to everybody. Happy to be back. So I was talking with Nancy a little bit before we started the program, and we were talking about whether or not I should, either kind of repeat what I gave last time. I don't know how many people were involved in the presentation last time. I don't necessarily want to repeat and have you listen to something that you've already heard. But what I'm going to do is I'm going to give a presentation that I normally give, but I'm going to cut it down a little bit. Usually what I start out doing is talking about the basics of estate planning, like wills and trusts, the basics of those. And then I get into some of the most common mistakes that people make in their estate planning and the mistakes that I deal with on almost a daily basis, so that people can understand that, yes, it's important to do estate planning, but it's also important to do it right. And so many people, unfortunately, either don't do it at all, or if they do make an attempt at it, it's wrong. There are problems, and those problems are discovered only after somebody's passed away. And now it's too late to really fix anything without going to court. So a lot of the work that I do, I would say probably 65 to 75% of the work that I do as a trust and estate attorney is court work. Now, normally as an estate planning attorney, estate planning is transactional by nature. We're creating documents. We're doing documents for clients, wills and trusts and powers of attorney, healthcare directives. That's what we should be doing. But the reality is, because most people, as I said, don't do any planning at all. So most people die without a will or a trust. Their estates are going to have to go through the probate court, through probate, which we'll talk about in a little bit, or they're going to have to go through court because there's fighting among the family members. When people pass away, family dynamics change, relationships within the family come out. Same people sometimes are harboring ill will towards their siblings, and often that comes out when somebody passes away. And so we end up dealing with a lot of those issues. So unfortunately, even though I feel I'm a transactional attorney and a big part of what I do on the estate planning side, most of my time is really spent in court, dealing with problems, dealing with situations where people didn't plan, or as I said, when people do their own estate plan. Nowadays, you can go on LegalZoom, you can go on Rocket Lawyer, you can go online, and people try to prepare their own documents, to prepare their own trust and will and other documents. And it's like anything else in life. When you're doing something yourself, you may or may not get it right. And the problem in the estate planning arena is that when you do your own estate plan, and if things are wrong, if you didn't get it right because you didn't complete the documents correctly or you made mistakes, those aren't going to come out right away, because you don't really use your estate planning documents initially when you create them, right? You pass away and then those documents come out. Something happens to you. So there's a death in the family or somebody becomes incapacitated. And it's only then those documents come to light, and it's only then that we'll find out whether or not they were done correctly. And many times we find out that they weren't done correctly, that there are mistakes that were made, that the trust was not properly funded. Sometimes the documents are very ambiguous. They are not clear about what was intended. And so where there's a provision in a trust that would have helped maybe one person in the family or one side of the family, maybe a different interpretation would help somebody else. And so now you've created a dispute within your trust, and a dispute among the family members, and everybody lawyers up, and then we end up in court. So a lot of times it's just that the documents aren't clear. They're not clear about what was intended. A lot of times there are problems where the the documents were created, but the trust was not properly funded, right? Somebody created a trust, but they didn't actually transfer the title of their properties to the trust. And so now we're going to end up in court anyway. So many, many things that can happen, not only if you do it yourself, but also if you go to somebody who doesn't know what they're doing. So some people do go to an attorney, and unfortunately those attorneys don't know what they're doing, or paralegals. You can go to We the People or other outfits like that who are paralegals who say they'll draft documents for you. And again, because they don't know what they're doing sometimes, or they don't have the experience they need to deal with a particular family situation, the documents are not correct. And so now we end up in court and we're fighting. So my job as an attorney, what I'd like to do, this is why I like to educate people. I like to talk to other professionals like yourselves to educate you so that you can see what are some of the most common mistakes that I'm dealing with? What are some of the most common problems that are out there? So that you can recognize these and hopefully when you talk to your clients about them, educate them as well. So that's what I'm going to talk to you about. I've got a screen to share. Now, look, what I'm going to do is I'm going to pare down my discussion from what I normally talk about, and I'm going to leave some room to talk a little bit about Prop 19. So I'm sure you've all heard about Proposition 19. That's that change in the law regarding property taxes and property tax reassessments and transfers between parent and child. And the other portion of that was the 55-year or older transfers, right? When somebody's going to buy a house and they want to transfer that property tax base to the new house, that law has changed substantially. And that law goes into effect on February 16th. So there's planning that can be done to help some people who are candidates for doing transfers now. So I'll talk a little bit about that as well, try to leave some room for that. I think that's probably going to be an important topic of discussion, maybe something that you're interested in, and we'll go from there. So let me just start my discussion with some basics. I'm going to share my screen with you and go over my PowerPoint presentation. So hopefully everybody can see the screen. If you can't, just let me know in the chat if there's a problem, and I'll fix that. So this is what I do. I'm a trust and estates lawyer. I've been doing this for the last 23 years. I'm a certified specialist in estate planning, probate, and trust law. This is all I do. My firm is about 20 people total. There's 7 attorneys, a number of paralegals and assistants, but all of us are dedicated exclusively to trust and estates work. This is what we do. So estate and tax planning is really what we're going to talk about today, but we also help trustees and executors when people pass away to administer the trust. They have certain duties and responsibilities when you're a trustee, and most people don't know what those are. So we guide them through that process and make sure that they carry out their duties and don't put themselves in a situation where they're going to get sued for doing things wrong. We also, as I mentioned, do probate and trust litigation. It's a big part of our practice, and then conservatorships and guardianships. So what we really want to talk about is estate planning, right? And what we're trying to do is we're trying to create, the goals are basically you want to be able to leave your property to the people that you choose. So you have to have a will or a trust that says that. Most people don't understand that if you die without a will or a trust, the state of California has a will for you. It's in the probate code. So that's what we're trying to do by doing our own estate plan, is you get to decide where your property goes rather than leaving it up to the state of California. So that's the first goal of estate planning. We also want to make sure that we leave property to our children at the right time, right? If something happens to you, you pass away, and your children either are not old enough to manage their own property because you died unexpectedly, or maybe you just don't trust them with the money. You think that they're going to just spend it all or blow it all within a year. There are ways to set up your trust to avoid that. But if you don't do anything, then they just get it all at the age of 18 or whatever age they are when you pass away if they're not minors. You also get to decide by doing an estate plan who's going to be in control of things, who's going to be your executor, your trustee, who's going to be making healthcare decisions for you. All of these things you can do if you have your own estate plan. But if you don't do anything, if you pass away, then again, the state of California in the probate code, it says who are the people that get to make those decisions for you. And the problem, of course, is that often it's more than one person. Let's say, for example, that I pass away and the people who are entitled to make decisions for me are my children. Well, I have more than one child, and often that ends up resulting in the very first fight in court is who gets to be the trustee or who gets to be the executor of the estate. Well, I don't want there to be a fight. I want there to be clarity about who I want to do that. And so it's important to do an estate plan for that purpose. And then by doing estate planning, you can maximize the amount that ultimately you pass to your children. If you don't do anything, you're going to ensure that there's going to be a lot more attorney's fees, executor fees, court fees, that are going to be paid by your estate as a result of the fact that you didn't plan properly. So if you do an estate plan, you get to maximize the amount that passes to your beneficiaries rather than going to all these other people, right? All right, so that's what we're trying to do. So what are some of the things we can do as an estate planning option? What are the documents that can be created? Well, I often talk about how people use joint tenancy as an estate planning tool. You don't really think about that normally as an estate planning tool, joint tenancy, but people use it that way. Let me explain that. So joint tenancy is simply a right, a manner of holding title to something. As you know, you can hold real estate as joint tenants, and it can be as many people as you want. You can have 4, 5, 6 people on title. And if they hold as joint tenants, the most important feature of a joint tenancy is, as you know, is the right of survivorship. So if one joint tenant passes away, automatically by right of survivorship, by law, it passes to the surviving joint tenants. There is no need for a will. There's no probate. It's just automatic by the way that the title is held. Now, that's why it's a common tool that people use for estate planning, because they don't have to go see an attorney. They don't have to get a will. They just do a quitclaim deed that adds their children or other people to the title of their property, so that when they pass away, it'll automatically pass to them. They do the same thing with bank accounts. You can hold joint tenancy bank accounts or investments. You can hold just about anything as joint tenants. But the problem is that what people don't understand is that when somebody passes away, or when you add somebody to the title of your property, you're giving them control immediately. You're giving them an ownership interest in the property. So let me talk about some of the problems with joint tenancy, okay? It's the worst way to hold title to anything. Let me just tell you that. It's one of the problems that I deal with most often in my practice. And it's the way that really almost everybody takes title nowadays, even nowadays with even though you have community property titling and other ways to hold title, the most common way that husband and wife still take title today is joint tenancy. And it's a problem. And I'm going to talk to you about why it's a problem. So let me talk to you in the context of cases that I've dealt with in situations where people have had joint tenancy and it's become a problem. So the first one is a situation where I have a client who added her children to the title of her property. So this was, her husband had recently passed away, and he passed away unexpectedly. He died at a young age, and she was not in good health either. She had 2 young sons who were adults, but still young in age. They were in their 20s. And those 2 sons were, of course, she was going to leave everything to them when she passed away. So she got some bad advice from a paralegal who told her, well, you can just add your sons to the title of your property, and if something happens to you, it'll automatically go to them. Well, that part of it is true. It will automatically pass to them. She didn't talk to them about the other problems with joint tenancy. So let me explain what happened in this case. So what happened is she added her children to the title. She records the deeds. About a year after she did that, one of her sons was involved in a very serious accident, a motorcycle accident, and he was left in a vegetative state, permanent vegetative state, unable to manage his affairs, unable to sign or unable to contract in any way. So now, about a year after that, she started experiencing, she had to take care of him, of course, and things started to become financially difficult for her, and she wanted to refinance the property or maybe even sell it. Unfortunately, she was not able to do that because her son was on title. She was not able to get his signature because of his incapacity. So now that's why she came to me. She came to me so that we could establish essentially a conservatorship, which is what I told her she had to do. We have to establish a conservatorship. So a conservatorship is a probate proceeding whereby a court is going to appoint somebody to have control over her son's financial affairs. Well, of course, that's her. She was going to file that petition to ask the court to give her the power to deal with her son's financial affairs so that she could refinance or sell the property. So we did that. We did that proceeding, and that proceeding, it's typically about 6 months or more. Now with COVID, there's some delays, and it's expensive. It cost her about $7,000 or $8,000 to initially establish that conservatorship. So with that power, now she had the power to sign for him. But because she had added him to the title, he was now a 1/3 owner of that property, and that 1/3 had to be controlled by the conservatorship. So when she sold the property, which she ended up doing, she sold it, 1/3 of those proceeds had to go to the conservatorship and be managed there. And she had to give court accountings annually. So it became a nightmare for her. And unfortunately, that's not what she intended, but people think that when they're adding the children to the title of their property, that it takes effect only at death. But that's not the case. That means that when you add somebody to the title of your property, they have an ownership interest now. And anything that may happen to them no, their problems are now going to become your problem. So in this case, he became incapacitated. She had to deal with it. I had another client who added her daughter to the title of her property, and that daughter ended up going through a divorce. And in the divorce proceeding, the husband brought that into the divorce proceeding, trying to claim a property interest in that, even though he was not on title, but because as a result of community property and in the marriage, he was claiming some interest in that. So this is what happens. Let me tell you another case, another situation. A client of mine called me, and from one day to the next, money in her account had been depleted. Money had been taken out. She had over $100,000, $120,000 in the account. And from one day to the next, it was gone. Nobody else was on the account with her, none of her children. But what we ended up finding out was that she had added her son as, I'm sorry, there was actually somebody on the account, her son. Her son was on the account with her. So she had added her son to the titling on the account so that he could have access to it. In case something happened to her, she wanted him to have access. Well, he didn't take the money, but what we found out was that a creditor of his, somebody who had sued him years prior and got a judgment against him, was able to find that account, find his name on the account, and they levied the account to pay off that debt that he owed. Now, she was not aware of the lawsuit. She wasn't aware of any of that, but we found out, of course, through the proceeding. And then what we ended up doing is having to get in there and show that, in fact, that money did not belong to the son. It actually belonged to her. So we ended up having to pay some of that money to the creditor to make them go away. She had to pay me some of my fees. But all that happened simply because she added him to the title. Now, fortunately, she didn't add him to the title of her real estate, because if she had done that, even that judgment would have attached to the property as well. So as I mentioned, when you add people to the title of your property, their problems become your problems. And I can't even tell you how many times I've had to deal with the situation. I'm dealing with it right now. I actually talked to a client last week where they added one child to the property. So this was parents some years ago. They were dad was going through some health issues. He was concerned about his hospital bills and thinking that, later if something were to happen to him and he had a huge hospital bill, that they would lose their house. So they ended up adding one of the children to the title of the property. And thinking, of course, and this was maybe 15 years ago that they did this, thinking, of course, that, hey, once that problem passes, we'll just have them transfer it back and it won't be a problem. So in that particular case, now we're asking for the title. I'm representing mom, asking for the title back, and the son is saying no. The son ended up creating his own trust and putting that property into the trust, and he's refusing to give it back to mom. And so now we're having to go to court, sue the son to get that property back. So these things happen. It's not a good idea to add people to the title of your property. There are other ways to resolve these issues that you may have. Now, let me tell you the last problem with joint tenancy. It involves husbands and wives and the way that they take title to property. So let me explain first, before I talk to you about the problem in this case that I had to deal with, let me talk to you some concepts about capital gains tax. So capital gains tax is an important concept. Obviously, when you buy a property, when I buy a property, let's say I buy a property for $500,000, and I hold on to that property, and some years later, it's now worth $800,000. And I decide I'm going to sell the property. Well, if I'm going to sell that property, I'm going to pay a capital gains tax, a tax on the right to sell that property. A tax will be the difference between what I paid for it, which is my basis, my tax basis, and what I sold it for. So if I bought it for 500, I sold it for 800,000, that's a $300,000 gain, and I'm going to pay capital gains taxes on that. Right now, maybe in the neighborhood of 30%, right? 20% federal and 10% state, or a little bit more than that. In any event, I'm going to pay capital gains taxes. So what about if I keep it? What if instead of selling it, I keep it, and at my death, I transfer it to my daughter, right? So now my daughter owns the property. The question is, what is her basis? What is the basis in her hands of that property? Well, what she got under the current law is a stepped up basis. So her basis is not what I paid for it, $500,000. It's the date of death value. So now her basis is actually $800,000. And if she went to sell it the day after I passed away, after I left it to her, she would have zero capital gains tax. So getting a stepped up basis when you leave property to your loved ones, or to anybody for that matter, is a huge benefit. Husbands and wives, if the property that you own is community property and you're able to show the IRS that this is a community property, then the surviving spouse gets a full stepped up basis on the entire property at the first death. Huge benefit again. Now, here's the problem. So I had a client who called me, and she was referred to me by her advisor, by her tax advisor, her CPA, because her husband, with whom she owned her property, her residence in Rancho Palos Verdes, she had bought this property many years ago for $150,000, $200,000, and now she was going to sell the property and it was worth several $1 million. So her husband had died about a year prior to the time she came to me, and she wanted to know, was she going to have to pay capital gains taxes when she sold the property? So we pulled the deed on the property, and how do you think it was titled? Joint tenancy. Unfortunately, the IRS does not recognize joint tenancy property as community property. Remember I said that you get a stepped up basis for community property, a full 100% stepped up basis if it's community property. Well, the IRS does not recognize joint tenancy as community, even though under California state law, they purchased it during the marriage. The presumption is that it's community property. If they were getting divorced, the divorce court would say, yes, it's community property. But the IRS is not bound by state law. They have their own rules, and they say, show me something that says this was community property. Well, she didn't have anything like that. So now, instead of getting a full 100% stepped up basis, she only got a 1/2 step up. Only his half, the deceased spouse's half, got stepped up. Her portion was still the basis of what it was when they purchased it 50 years ago at $150,000. So now she goes to sell the property, which she did. She had to pay several $100,000 in capital gains tax, all because it was titled as joint tenants rather than community property. So you can see it's the problems with joint tenancy. Now, I'm not saying that you should go out and tell all your clients, hey, don't title it to joint tenants, title it as community property. No, that's not your job. Your job is not to advise them. I'm sure they ask you, how should we take title of the property? What you can do now is you now understand where the problems may lie. And so you should tell them, advise them to speak with an attorney, refer them to an attorney to tell them, hey, you should talk to an attorney about how you should take title. There are different ways to do that. The other thing it tells you, if they're asking you, they don't have a trust. So that's obviously, if you have real estate, you need to have a trust to avoid probate later. So it's another thing to advise them, say, hey, you need to speak with an attorney about getting a trust and about maybe the best way to hold title of property. So that's a problem with joint tenancy, all right? Now, let me see if there's any. I'm going to stop the share for a second to see if there's any questions. All right. Yeah, somebody asked me if it's available for download. Yes, I'll go ahead and email this so that you can have my PowerPoint presentation. I'll email it to Nancy. All right. Does my step up basis also step up on income property? Yes. So the stepped up basis is not just for your personal residence, it's also for income property. That's the current law. The current law is that any property that you have, and it's not just real estate, it's stocks. If you own stocks, not retirement accounts, but any stocks you may have in a brokerage account or the company that you own, anything that has a basis on it, your cost basis gets stepped up at the date of death value. Now, let me just tell you that that law may change, right? Right now, as you know, there's going to be a change in administration. Joe Biden's tax policies are much different than Trump's. So in his tax plan, part of his tax plan is to do away with the capital gains with a stepped up basis. So we don't know what's going to happen. We don't know whether he'll have the votes for that or what's going to end up happening, but it's going to likely change at some point. Even he's trying to do away with 1031 exchanges. So we don't know what's going to happen, but just be aware of that. Another question, if we have rental property in an LLC, can we put the LLC into a trust? Yes, if you have rental property, not only can you put it into a trust, it should be part of your trust. Your LLC needs to be part of your trust. So when you do an LLC, we do an assignment of the stock of your membership interests into the trust. So the trust should be the owner of that, because if something happens to you, you want your successor trustee to have control over the LLC. And the only way to do that is to do an assignment of that into the trust. And by the way, property in an LLC, that's also gets stepped up basis, okay? All right, so let me go back to my share screen, my PowerPoint presentation, and share with you some other information. Okay, so we talked about joint tenancy not being a good estate planning option. So what are some of the other options? Well, one other option, of course, is to do a simple will. A will is simply a document that states where your property goes when you pass away, right? So if you have a will, at least in your will, you get to express where things go. It's not going to be the state of California. If you die intestate, remember the state of California, you have to look at the probate code to see who's going to inherit from you. Not so if you have a will. So a will is better than nothing because a will at least expresses your wishes about not only who's going to get your property, but also who's going to be your executor, so that there's not that fight in the court over who's going to be in control of your estate. So you have that, that's good. The problem, however, with a will is that wills are subject to probate. So even though you may have done a will, it's not going to avoid probate. In fact, wills are going to guarantee that you're going to go through probate. If all you have is a will, wills get probated. And the purpose of probate when you have a will is to prove that the will is, you have to prove to the court that the will is valid, that it was properly executed, properly witnessed, that it has all of the requirements for a valid will. And in there, if the court approves that, then your estate can be distributed. But here's the problem with probate. There are a number of problems with probate. Number one is that there's no privacy. Probate happens in an open court proceeding. Anybody can literally go down to the courthouse and pull your file and see what you have and where you have it, where property is going, the names and addresses of all your beneficiaries is all there. Nobody wants that information to be given access to the public, but it is. So that's the number one. That's one of the problems with probate is no privacy. Everybody else gets to see what you had and where it's going and names and addresses of people that you'd rather keep private. The other thing is that in probate court, in probate, you're in a court. In a courtroom, what happens in courtrooms all across the state and the United States? People are involved in disputes. It's a place where litigation happens. Probate court is no different. That's a place where it invites litigation. If your estate's going to go through the courts because it's got to go through probate, it's going to just invite litigation. Claims from other people who claim the decedent owe them money. It's going to invite claims from somebody who wants to challenge the will. It's going to invite litigation among the beneficiaries and maybe the executor because they don't agree with what he's doing. In other words, it just invites litigation and it's going to make your estate much more costly. Time delays. It takes now over a year to go through the probate process, right? With COVID and the time delays associated with that, it takes over a year now to get through that probate process. So time delays, and your estate, your family is not entitled to receive the funds, the proceeds, until after the probate is done. So it can be delays of a year, 2 years, or longer. The other thing is that probate is expensive. The attorney's fees, the executor's fees, the court costs, all of that are based on the size of the estate. So in the probate code, it has a schedule. It's a sliding scale because the larger the estate, the higher the fees. And so I'll give you an example. If your estate is if the estate that's being probated is valued at $500,000, let's say it's just a house in California, that's it, there's nothing else, and it's valued at $500,000, the attorney's fee is $13,000 for that. That's for the regular ordinary compensation for the attorney, $13,000, but you have to multiply that by 2 because it is the executor or the administrator of the estate gets the exact same fee. So now you're at $26,000, and then you've got about $3,000 or $4,000 in costs. So we're talking about well over $30,000 to probate a house in California. Now, if the house has a $400,000 mortgage against it, then the net estate is only worth $100,000, but the fees are still based on the $500,000 gross value. They don't deduct for mortgages. So it's a very onerous fee. And you can see as the estate is larger, the fees go up. Now that's only for what I call ordinary compensation. Ordinary, meaning that if you're going through probate, these are the fees you're going to get paid no matter what. But attorneys and executors are also entitled to take extraordinary fees or extraordinary compensation for services beyond the normal probate. If there's going to be fighting in the estate, if there's litigation going on, if there are claims being made against the estate and the attorney has to defend those claims, all of those fees can be charged against the estate. The attorney gets to charge their normal hourly rate. In addition to this fee, they get to charge their normal hourly rate. I had an estate once where I was the attorney and my statutory fee, because the estate was only $300,000, was $7,000. But my extraordinary fee for all the work that was going on because of the litigation, the fighting going on among the beneficiaries was $32,000. So I'm telling you, it's just onerous. So you want to avoid these fees if you can, right? So the other problem with probate, let me just tell you here, is that probate is a place where if there's a Medi-Cal claim that's going to be made against the estate because the decedent was receiving government benefits during their lifetime, Medi-Cal can make a recovery claim in a probate, right? If you're going through probate, they can make a claim. And I'll tell you, some of these claims that I've seen basically wipe out the estate, right? If the person who was deceased was receiving government benefits for many years it's a big tab that's owed at the end, and they get to claim that the entire thing. So sometimes that Medi-Cal claim completely wipes out the estate. If you have a trust, which I'll talk about in a moment, that's going to avoid those claims. Medi-Cal cannot come in and make a claim against a trust if your property is in a trust. So it's a big difference. So how do we avoid probate? You avoid probate by having a living trust. So a living trust is a will substitute. It does the exact same thing that a will does. In the trust, you get to state where your property goes when you pass away, right? There are three key positions within all trusts. Creator, often referred to as the settlor, the grantor, or the trustor. It's the same thing. It's the person who creates the trust. All trusts have to have a trustee. That's the person who has control over the assets, who is able to invest the trust money, control the trust money, spend it, distribute it to the beneficiaries. That's the trustee. And then the beneficiary of the trust, of course, is the owner. That's the person who owns all the property in the trust. So when if I'm going to create the Paul Velasco Trust, I am going to occupy all three of these positions. So all three of these positions are occupied by me. I'm the creator, I'm the trustee because I still want to be in control of my property when I put it into the trust, and I'm the beneficiary. I still want to own these assets. I'm not giving it away to anybody yet. I'm keeping it all in my trust. So a trust is a contract with myself. At its core, a trust is a contract. If you're a married couple doing a trust, you do this contract with each other. If it's a single person, then it's a contract with myself. And this contract controls the trust property for my entire lifetime, right? For a married couple, it controls all the property during your joint lifetimes. There's a control of it at the first death, what happens at the death of the first spouse, and then where does it go when you pass away? So that trust contract controls everything. So when I create a trust, it's not enough for me just to sign the trust and put it away. And I will tell you, that's a mistake that many people make. They just sign it, they put it away, there's nothing else, they don't do anything else with it. Well, that trust is empty. Think of your trust as a box that you created, right? If you create this box, but you don't put anything in it, it's not serving its purpose, right? If you create a trust and you give somebody else the key to the box, because what I did was when I created this box, I transferred all of my property into the trust. I did deeds to transfer my title of my real estate into the trust, my business, my corporation into the trust, my bank accounts, my investments, the beneficiary of my life insurance, everything is now in that box. And now I have the key to the box during my lifetime, but at my death, I'm handing that key to somebody else. I'm naming a successor trustee. That trustee has the key to the box and can now carry out the contract. That contract now says at my death, my trustee, my successor trustee, steps in to get control of all of my assets, pay off all of my debts, tax expenses, and then distribute the property to my beneficiaries as stated in the trust. That's the contract. And the trustee, with that trust document, with that key, has all the power and authority they need to do that. They can literally take that trust to the bank and get control of all of their bank accounts that are in the trust. They can record deeds that give them control over the real estate. They'll have control over the LLCs and corporate interests and your business interests. They'll be able to collect the life insurance where the trust was designated as the beneficiary. All of these things are done with that trust document. That's why we don't need probate. In probate, it's the court appointing somebody and giving them the court authority to go get all these assets that are in the decedent's name. We don't need that when you have a living trust. That trust document gives the successor trustee all the power and authority they need to administer your trust without having to go to court. So that's the main difference between a will and a trust is probate avoidance, right? So what's the main differences besides that between a will and a trust? Well, let me get down here. So a living trust avoids probate. We just talked about it. It also avoids a conservatorship. If instead of passing away, I became incapacitated and unable to manage my own affairs. If I had an accident, I'm in the hospital. If I became, had Alzheimer's or dementia and I can no longer manage my own financial affairs, my successor trustee gets to step in and do that and manage everything. Again, no need to go to court to establish a conservatorship. As I mentioned earlier, a living trust avoids Medi-Cal claims. Medi-Cal cannot come in under the current law and make a claim against property that's in a trust, so it protects against that. It also makes it more difficult for creditors, hospitals and credit card companies to make a claim against your trust. If it's in a probate, it's almost automatic. They just file their creditor's claim in the probate and the judge makes sure that they get paid before anybody else gets their money. but it's much more difficult for them to do that when there's a trust involved. Also, privacy. Remember I said that in a probate proceeding that all your assets are open to the world. It's basically your assets and the names and addresses of your beneficiaries are all there. It's like an open book. That's not so with a living trust. When somebody passes away, it's a private administration. Nobody gets to see what you had. Nobody gets to see a copy of the trust, only the beneficiaries. So all of that remains private. All right, so now I'm going to stop my share again and see if there's any other questions before I move on. Can Medicare make a claim against a probate or a trust? I think I just answered that. So the answer is Medicare, Medi-Cal. Oh, Medicare. No, Medicare is not going to make any claims. It's Medi-Cal benefits. Typically like nursing home. You're in a nursing home, those kinds of benefits that get paid out are the kinds of claims that are made by Medi-Cal later, not Medicare. It's a different insurance program. You know, they don't seek reimbursement after your death. Is it typical for there to be a will inside the trust? That's a great question. So yes, it is. So it's not enough to just have a trust. Okay, so let me get to my share screen again. Let me get to the end of my presentation. It's not enough just to have a trust. There are other documents that form part of your estate plan when we do a trust. So a complete estate plan includes not only a trust, but other documents as well. Let me explain what those are. Number one is a will, we call it a pour-over will. Even though you have a trust, we do a will only as a backup document, right? The purpose of that is this. Remember I said that if you, when you have a trust, it's not enough for you to just create the trust and put it away. You have to fund it. You have to put your property into the trust. You don't want to leave your trust empty. So we create a trust and we put all the client's property into the trust. We assist our clients with that. We prepare the deeds, we record the deeds, we give them letters to give to their banks so that those bank accounts are put into the trust. We do the same thing for their other assets. So all of that is now in the trust. But often what happens is people, as they go forward and go through life, they acquire new things. They buy new properties, they open up new bank accounts, they buy stocks, they start a business, and many times they just forget. My instructions to them is always, hey, as you acquire new things, make sure you put everything in the trust. Don't put it in your name anymore, in your individual name. But people just forget, they don't think about it. So now somebody passes away, often we see, and it's more common than not, where they do have some assets in their trust, but then there are things that are in their individual name because they opened up new accounts and acquired assets in their name. The will catches those things, and the will says, at my death, I leave everything to my trust. So it's a backup document only. If when somebody passes away and they have a trust, all their assets are in their trust, then we don't need the wills. The wills are just, they will be ignored. We don't need them. But in many situations, we do need to get that will to be able to use it to get the assets, whatever was left out inadvertently, get it into the trust. So that's what a pour-over will is for. So yes, you do both. You do a trust and a will. You also do a power of attorney. So if you become incapacitated and can no longer manage your own financial affairs, then you have somebody who's able to do that for you. You name somebody as your power of attorney in the event of incapacity to be able to manage your accounts and pay your bills and file your tax returns and deal with Social Security or other government agencies, to defend a lawsuit if somebody sued you or pursue a lawsuit on your behalf, to deal with Medi-Cal issues. All of these things are done with the power of attorney. So you need that document as well. You also need an advanced healthcare directive. If you can't make healthcare decisions for yourself, then somebody's got to do that for you. In there, you name the people that you would want making those decisions for you. And in there, you also state what your wishes are. So do you want to be kept on life support if you're in an irreversible condition? Are you an organ donor? Do you want to be cremated or buried? So in here, you'll make important decisions for your agents to know, and then you'll name the people who are going to make those decisions for you when the time comes. So the advanced healthcare directive is important. We do also a property agreement for married couples. What is that for? Remember how I talked earlier about the importance of titling your property as community property? Well, this property agreement for married couples says we consider all of our assets to be community property, except these things. Maybe there's something that we're keeping separate in the marriage, something they inherited or something they had prior to the marriage, then we would list that in there. But otherwise, we tell the IRS through this agreement, hey, we consider everything we own to be community property. That gives us the stepped up basis that we were talking about earlier, that important stepped up basis. So we do that for property agreements. We do that for couples. We prepare letters so that they can transfer things into the trust. We give them letters that they can pass on to their financial institutions. We do the deeds to put their properties into the trust. We prepare beneficiary designations for their retirement accounts. So all of these things comprise what we call an estate plan, which is a plan for the management of your property in the event of your incapacity and for the distribution of your estate at your death, all while avoiding these court processes that would otherwise be there if you didn't have these documents in place. So what is the cost of all of this? So let me explain a little bit about our process. So our process is this: when we meet with clients, we don't charge for the initial consultation. So they meet with us, we give them an hour and a half of our time. We go through their scenarios. We want to know what their family situation is, because nobody's the same. We don't just use these boilerplate documents and just plug different names in. No, every plan is different. Every plan is tailored to that particular family. So we get their family information. We have a discussion with them about how they want to set things up. We then make a recommendation. This is how we would recommend setting up your estate plan. And then we tell them what we would charge to do the work. So typically for a single person's estate plan, it's going to be somewhere around $2,500 to do all these documents. And for a married couple, it's about $2,900. So 25 and 29. And if there's more than one property, because that includes a transfer of their property into the trust. Remember, we have to record those deeds. If there's more than one property, then we charge $125 per deed for additional deeds that need to get put into the trust. So it just depends on what their situation is. Those are average costs for an estate plan. Right now, if you compare that with what the attorney's fee is in a $500,000 probate, the attorney's fee is $13,000, the executor's fee is $13,000. It's a no-brainer. So this is why it's important to do estate planning. All right, I'm going to stop to share and answer a few more questions, and then I'll talk to you a little bit about Prop 19. All right, yes, we will mail I'll email. I'm not going to email the PowerPoint presentation to all of you individually. I appreciate your giving me your email addresses. I'm just going to email it to Nancy, and then she can send it on to you guys, okay?
Yeah, just send me an email. My email is noakley@cvar.net. If you just send me a quick email and say, hey, Nancy, send me the slides from estate planning class, I'll go ahead and send them out to you once I receive them. So thank you so much.
All right. Thank you for that, Nancy. All right. So the next question I would like a PowerPoint. Everybody's wanting a PowerPoint presentation. That's good. I'm happy that you guys, that you find this information useful. It'll help you. I'll be happy to answer questions you may have. If a decedent signed a simple, revocable transfer upon death deed prior to death, would the property still need to go into probate? Well, it depends. It depends. There are problems that will tell you with these transfer on death deeds. I don't use them. People call me, ask them, will I do that? I don't do that. I don't touch those. There's potential problems with those. I'll just tell you a couple, but let me answer this question first. So yes, if you do a transfer on death deed, as you know, a transfer on death deed is simply a deed that says, at my death, this property goes to, and then you name the person that you want to receive it. But what if you do that and you name somebody and that person passes away before you and you don't do anything, right? So if I named my brother, for example, as my beneficiary of my property, and then he dies before me and I don't do anything with that deed, and then I die, well, that property is going to go through probate because the person passed away before me and now we're in a probate situation. If instead I have a living trust and I leave my property to my brother and he dies before me, the trust is going to say where that property goes in the event that he dies before me. So there is no probate. That trust controls everything. So the trust can account for contingencies. If people you designated in your trust pass away before you, there's already a plan for where it would go after that. But you can't do that in a transfer upon death deed. The other thing that happens, and I'll just tell you a situation where a client of mine, we had to deal with this problem where he held property jointly with his sister. So he held property jointly with his sister, and then he did a transfer on death deed to transfer the property to his daughter. So thinking that when he passed away, the property would go to his daughter. But what happened is he passed away, but the sister, who was the other person on the joint tenancy deed, survived him. She was still alive. And so that property went to the sister. That joint tenancy deed controls it. The transfer on death deed is only if sister had died first. Then that property would have gone to his daughter, but she didn't. Sister survived, so that property went, and the transfer on death deed was not effective to do what he intended it to do. So if you want to do a transfer on death deed and you own property jointly with somebody else, you have to sever that joint tenancy so that you own that 50% only as a tenant in common. Then you can do the transfer on death deed, but that's not what happened. I will just tell you, there's all kinds of problems that happen with these transfer on death deeds. But yes, they're available, they can be done, but it's not anything that I would advise people to do. All right, let's see. What is the difference on a living trust and a family trust? There is no difference. These names are all synonymous: living trust, family trust, revocable trust. They all mean the same thing. So there's no difference. All right, so let me talk a little bit now about just the Prop 19. Right, I don't have a PowerPoint presentation for that. I'll just tell you about a little bit about the law and what's changed and maybe some of the things that we're doing. Don't know what the time is, but let's check my time on this. I've got about 10 minutes. So Prop 19, as you know, was a proposition that was passed in November. It was barely passed by like 51% of the vote. So it barely passed, but it did pass. This was actually a proposition that was put forth by the California Association of Realtors. So you guys, right, your organization put this together and did this. And the reason that they did it was, I think, and it's clear, it's not anything that's a secret, but the idea was that it would spur sales, that when people pass away and leave their property to their family, that because the properties are going to get reassessed now, that many of those children who would otherwise keep them, if they were going to keep the same property tax base, are now going to sell them. And so that's obviously more business opportunities for the real estate profession. And that's a good thing for them. So that's, I think, one of the reasons they were sponsored by CAR. But I will tell you, it was not very clear about what this proposition was. Most people before they voted, even at the time they voted for it, didn't really know the effect of this proposition because it was really marketed as something that was beneficial to seniors and to wildfire victims and to the disabled, because it was going to expand that Proposition 60 and Proposition 90, where seniors 55 years and older, remember, they could sell a property and then in one county and move it to another property and move their property tax base to the new property. So they expanded on that, and that's really what the sponsors of the bill focused on. They didn't really talk about the other portion of Prop 19, which has really had the biggest effect. And that was basically to do away, for the most part, with reassessment exclusions for transfers between parent and child. So it used to be that if you pass away and you leave your principal residence, your home, to your children or to a child, that property would not be reassessed. And there was no limit. I mean, you could leave a property that was worth $20 million to your children and the property taxes wouldn't change. So that was a huge benefit. Now, for properties other than your personal residence, so if you have rental properties or commercial properties, the other part of that is that you can exclude a $1 million of assessed value for those properties as well. So if you have other properties and you have low property tax bases, then you can exclude up to $1 million total. So let's say I have clients who have had properties for many, many years, going back 30, 40, 50 years, and their property taxes are very low. And so their assessed values, it's not fair market value. So that $1 million doesn't apply to fair market value. It applies to the assessed values. So as an example, I have a client who's got 4 properties in LA, and if we add up the assessed value of all those properties, because she bought them so long ago, they're right about $900,000. So she, under the current law, would be able to pass not only her personal residence, but also those rental properties, she would be able to pass to her children with no reassessment, because the total value is under her $1 million exclusion. Well, with Prop 19, it did a couple of things. Number one is it did away completely with the $1 million exclusion. So in other words, any property that is not your personal residence, any rental property, commercial property, industrial property that you're leaving to your children or anybody else is going to get reassessed no matter what. So there's no more $1 million exclusion after February 16th. And the other thing is that for your principal residence now, there's a limitation. There's a limitation on the reassessment. You don't get to transfer. So you have a $4 million property, you don't get to transfer the whole thing without being reassessed. There's an adjustment. The other thing is that there's now 2 requirements. The one requirement is that it's got to be the principal residence, of course, of the deceased person. And it also has to be the principal residence of the child. That requirement wasn't there before. You could just pass, if it was your principal residence, you can pass it on to your children, whether they were going to use it as a rental or not, it didn't matter. They would still get the exclusion. But that's not the case anymore. Now, in order for it to qualify, it also has to be the child's principal residence, okay? So that's the situation. So now if it's their principal, and by the way, they have 1 year to establish that as their principal residence after the death of the deceased person, 1 year. So if you can, within 1 year, establish that that's your personal residence, the child, then they can get that reassessment exclusion, but it's limited. So it's limited to, well, let me explain it by, so here's it's a little confusing, but let me explain the rule. What it says is that if the value of the property, now I'm talking about the fair market value, if the value of the residence at the time of transfer exceeds the assessed value by $1 million, then the child takes, by less than $1 million. I'm going to give you an example. Then the child takes the assessed value. Let me give you an example of that, because that rule even confuses me. Let me give you an example. So let's say that I have a residence and it's worth $2.5 million, right? I've had it for a long time. My residence is worth $2.5 million. Under the new law, Prop 19, is if I pass away and I leave this to my daughter and she's going to use that as her principal residence now, no problem, we can do that, but it's limited. And she doesn't get to use the exact same property tax base I have. There's an adjustment. And the way that adjustment is figured is this. So you take the $2.5 million of fair market value and you subtract from that the current assessed value. What's my current assessed value? Let's say my current assessed value, because I bought it so long ago, was only $500,000. So on my property tax bill, it says the assessed value of this property is $500,000, but it's worth $2.5 million. So now, if what we have to do is, in order to calculate what my daughter's new property taxes base is going to be, is I take the fair market value, I subtract the current assessed value, so 2.5 million. Now I take the current assessed value, I subtract that. Now I'm at $2 million. So 2.5 million fair market value. I subtract my assessed value of 500,000. Now I've got $2 million. And then, because now that is in excess of $1 million, now there's going to be an adjustment. So that the adjustment is this. The adjustment is this. I take my current fair market value, 2.5 million, and I subtract $1 million, because that's the total limit that I get, the total adjustment. So I have 2 million, 2.5 million, and I have $1 million. I subtract, and that leaves me with 1.5 million. So now the assessed value of this property, even though it's going to be her principal residence, is going to be what it's going to be valued, assessed at a $1.5 million value, right? Under the old rule, she would have got it at my 500,000. Under the new rule, no, there's going to be an adjustment because it's only limited to $1 million, and that adjustment is done that way. So that's how that works. And so unfortunately, it's very limited now, because most of my clients whose children have their own homes, and they're not going to use that as their principal residence, so it's likely not even going to qualify for that. So it's very limited in that situation. All right. So now that I've probably thoroughly confused many of you, let me just tell you what some of the planning that we're doing in that situation, right? So now I'm getting calls, after Prop 19 passed, I'm getting all kinds of calls from clients saying, okay, well, what do I do now? What can I do? Because I want to leave my property to my children, but I want it to get reassessed when I pass away, because anything after February 16th is going to get reassessed. And putting it in a trust, it does not avoid that. It doesn't matter. A trust, when you're looking at property taxes through a trust, all you're looking to see is who's the beneficiary of that trust. If it's your children, it doesn't matter. Those same rules apply. A trust doesn't do anything. So you're still going to get reassessed. So the question is, okay, should I do something now in order to avoid this reassessment later when I pass away? Well, in some situations, clients will, but I will tell you, in the vast majority of situations, my clients are not doing anything, right? So especially your clients who are younger, who are in their 50s and 60s, they're just not going to do anything, because what it requires you to do is to transfer your property now to your children before February 16th, so that we can qualify for that under the current law. They still qualify for that reassessment exclusion. But if I transfer it to them now, I can get the reassessment exclusion, but it's no longer your property. And so if somebody who's in their 50s and 60s and still living in their property, there's still a mortgage on the property, it doesn't make sense to do that. It doesn't make sense to transfer your property now just so that you can avoid property taxes for your children 30 years from now when you pass away. It doesn't make sense. So for most people, they're not going to do anything, right? But look, there are plenty of people, and I have plenty of clients for whom it does make sense. And I'll give you some examples. So I have clients, for example, who many of these are my clients, and their parents are still alive, but their parents are elderly. Their parents are, I'll give you one particular case. So I have a client whose mother is 93 years old and not in great health, right? So, and she has her home and 3 other rental properties that she's had for many, many years. Everything is going to her son, and then she has a trust, and everything is going to her son in trust. So we know that, I mean, she's not, unfortunately, is not very long for this world. And so we know she's going to pass away at some point in the near future. Even if she lasts another 5 years, which is unlikely, but even if she does, even in that time period, she's going to lose the property tax. Her son is going to lose that property tax exclusion. So what we're doing is we're creating an irrevocable trust, an irrevocable trust. Her son is going to be the beneficiary of that trust. So as the beneficiary of the trust, the property tax assessor deems him to be the owner of whatever's in that trust. So we create the irrevocable trust. We transfer her properties today into that trust. That trust now owns the properties, and her son is the beneficiary of those. So now we can record those deeds, putting it into the trust. We apply for the property tax exclusion. So her residence gets to be excluded, even though it's worth $2 million, no reassessment. But the other properties, remember those 3 properties that she had, again, we're under the $1 million exclusion. So we're under the $1 million exclusion. So we don't have to worry about that. So we can still get all those properties into the irrevocable trust. We can still get them all into the irrevocable trust, no reassessment. So now we've done that. We've transferred everything into that irrevocable trust. The son is now, as the trustee, the owner of those properties. We've also made mom the co-trustee of those properties, okay? And we put special provisions in the trust, which I'll explain in a moment. So now everything's there. We've transferred everything. Property tax reassessment. Now when mom dies in the future, it doesn't matter for property tax purposes. There is no going to be any reassessment because we've already transferred that before the February 16th deadline, right? Now, these things are not simple because in many situations, what you're doing is you're trading one type of tax for another. So in this case, it had to make sense because he intends to keep those properties for many years. He intends to keep the properties and not sell them. His intent is not to sell them when your mom passes away. He wants to keep them. So having that same property tax base is going to save him tens of thousands of dollars over the lifetime that he keeps those properties. So it made sense to do it now. That property tax was very important to him. But there's a stepped up basis problem. Remember, I said that when you give your property to your children at death, you get a stepped up basis. Well, she's not giving it to him at death. She's giving it to him at life, during lifetime. So that is a carryover basis. Her basis, her income tax basis for determining capital gains when that property is sold later is now going to transfer over to him. And she bought those properties many years ago. So she has a very low income tax basis. So now in the future, when he sells those properties, there may be a capital gains tax, right? Whereas before it would get stepped up to the date of death value. Now it's not. It's going to stay at that value because it's a transfer during lifetime. But what we've done in the trust is we've included special provisions in the trust that allow mom to hold on to certain rights in that property, the right to control the distribution to her son during her lifetime. And by doing that, the IRS says that's not a completed gift for estate tax purposes. For transfer tax purposes, they don't recognize it as a completed gift. So what that means is that when mom dies, that property is still considered to be hers for estate tax purposes, which gets us the full stepped up basis. Okay, full stepped up basis. So we're trying to get both here. So obviously the IRS may argue otherwise. And so what I'm telling my clients is, hey, we can't guarantee that you're going to get that stepped up basis, but based on the current rules, the current IRS, your Internal Revenue Code, we're doing everything so that that property would still get a stepped up basis, but the IRS may argue otherwise. So we're not guaranteeing anything when it comes to basis, but we're guaranteeing that, hey, you're going to get to keep the same property taxes. And at the end of the day, that's what's more important to them, that property tax basis, because the income tax, the capital gains tax only comes about if you're going to sell the real estate at some point in the future. So, you know, they've chosen at this time, they're thinking that they're not going to sell it. And, you know, we don't have a crystal ball. We don't know for sure, but they'll deal with those capital gains tax issues later. They'll do 1031 exchanges to avoid capital gains, for example. So those are the kinds of things that we're doing. I'll give you another example. One other way that we're doing the property tax changes. And I think I'm almost out of time. So I want to be respectful of your time. So if you want me to continue to talk, I'll do that for another 5 minutes or so. And those of you who can't stay, I understand. So let me just talk about one other way that we're transferring. So what we're doing is we're transferring to properties. We're doing this. So let me give you an example. It's easier for me to explain it with a client. So I have a client who has a property that is a commercial property that they've had, you know, for again, 40, 50 years. That commercial property has a very low property tax base. And so the kids, the business, the family business is there. So if right now it was held in an LLC, right? By mom. Mom held this property in an LLC for asset protection purposes. And so what we're doing is we took that property out of the LLC and gave it back to mom. Okay. Mom now gifts 50% of the property to her children. She keeps the other 50%, right? So now children have 50%, mom has 50%. Again, that transfer between parent and child, no reassessment. We're now going to create a new LLC, and which we've already done, by the way. We put that into the new LLC. So now mom has a new LLC. She owns 50% of the LLC because she owned 50% of the property. The children own the other 50% of the LLC. And now the property is in an LLC. The rules for transfers when your property is in an entity are different than they are when they're in your individual name. The rule is that if you have property in an entity, the property tax gets reassessed when there's more than a 50% transfer of the property inside. So I'm sorry, a 50% transfer of the LLC. So when there's more 50% transfer of the LLC, all the properties get reassessed. But when mom dies, she's only giving 50%. So because it's not more than 50%, there's no reassessment. So all the properties go to, the LLC goes to the children. They now will have 100%. And the property taxes will not get reassessed because mom only transferred 50%. And with that rule for entities, there's no reassessment. So these are some of the things that we're doing for our clients to help avoid reassessment in the right cases, okay? So let me go. I think I see some questions here real quick. I've got to go soon because I've got a 3:15 Zoom meeting, but let me just see if I can answer a couple questions here. If there are two heirs, do they reassess half? So if there are two children who are going to receive, let's say that mom, again, this is only going to count now after February 16th for your personal residence. So if you have your personal residence and you're going to leave it to two children, but only one of them is going to live there, then only 50% gets to avoid that reassessment. Remember, you have to have it as your principal residence. If the other one's not going to live there, then they don't get it. So that child doesn't get it. So it's 50% would be subject to reassessment, but the other 50% for the child who's going to live there gets to get that property tax reassessment exclusion. Is the $1 million you talk about for principal residence? $2 million if a couple leaves house to one daughter. Yes. So the $1 million of exclusion from assessed value is $1 million per person. So yes, mom and dad get $1 million per person. But you don't, under the current law, you don't have to use that with your principal residence. Your principal residence gets to go to her, again, under the current law, gets to go to your children without using any of your $1 million exclusion. It's anything other than a personal residence that you count for that $1 million exclusion. Yes, mom and dad get each $1 million. How long does the process take for name transfer from an inheritance? That's really more of a trust question, but typically, you know, it takes about maybe 9 months to a year to administer a trust. So typically about a year. A living trust is not a living will. Is this Is this correct? That's correct. A living trust is not a living will. A living will is a healthcare document. It's confusing. People think a living will is some type of a will. It's not a will in the sense that you know it. A living will is that part of the healthcare directive that says whether you want to be kept on life support or not, if you're in an irreversible condition. That's a living will. Regarding Prop 19, can you give us another scenario with the house fair market value 675 and assessments are 26? Yeah, I can tell you right now that if it's at 675, then there is. So let me tell you where there's not going to be a reassessment, right? So let's say, well, it's 675 and the assessed value is $250,000. So real property value 675, assessed value is 275. So you go through the formula, right? The fact is, when you say, okay, what you do is you take the current fair market value of the property, okay, 675 minus 250, whatever that leaves you, it's 475, 425. 425. That's less than $1 million. So remember, you get the million up to $1 million of exclusions. That's less than $1 million. So there is no reassessment of that property at all. It stays at the same $250,000 assessed value that mom or dad had. So in that situation where you're under the $1 million there, when you do the calculation, there's no reassessment at all. It's only if the fair market value minus the assessed value, if it's more than $1 million, then it's going to be it's going to get reassessed with that adjustment we talked about. All right. Okay, I think that's it. How long does the successor trustee to sell the properties and execute the trust instructions? How long does the successor trustee have to sell the properties? There's no black and white rule. So when somebody dies, the trustee's administering the trust. There's no black and white rule that says they have to sell the properties within a certain time. They have to distribute the trust within a certain time. The rule is that it has to be done within a reasonable time period. And that depends on a number of factors, on how complex the estate is. Is there estate tax returns that have to be filed? Is there litigation going on in the estate? So all of that can delay the final distribution. But if it's not, if it's simple, if you have some properties and some investments and there's no litigation going on, then typically, if the property is distributed within a year of death, then you're just looking at a reasonable time. You know, beyond that, it can be argued either way. So that's what I have for you. So guys, look, I appreciate all of you, coming aboard today and listening to me talk at you for the last hour and a half. Hopefully you got something out of it. I'm happy to help out, or you can use me as a resource if you have questions going forward. I'm happy to assist you in any way I can.
Awesome. Thank you so much, Paul. We really appreciate it. You really outlined everything for us. And if anybody wants a copy of the slides, again, please send me an email. It's noakley@cvar.net. And once I get those slides, I'll send them on out to you. Anybody who's emailed me. So again, noakley@cvar.net. Thank you so much for being here today. A replay of today's session will be posted to cvar.live most likely by the end of the week, so you can rewatch anything that you missed from today's class. So with that, thank you so much, Paul, for being here. We really appreciate it. And to everyone who attended, thank you all so much for tuning in. We'll see you at our next classes. Have a great day.
All right, you bet. Thank you. Thank you, everybody.